So then the question becomes, why isn't the U.S. under the jurisdiction of the Hague or the International Criminal Court? And that is a complicated answer. So, like I said, Clinton was in office when it was starting to be built up. And the Clinton administration decided not to sign or submit it to Senate or congressional review because they were very concerned that it would be subject to political influence from the court. That isn't possible. There's a lot of checks and balances in the court to make sure that the things that they pursue are in fact the following the Rome Statute that they hold as their boundary line. That was in 2000. Then George W. Bush took over, and as I said, the Rome Statute went into effect and was accepted by numerous countries and rejected by 7, the U.S. being one of them. We had just come off of 9/11. We were still pursuing the information that began the Afghan war. And we stated that we would not join the ICC. The Obama administration reestablished a working relationship with the court as an observer. So as I said, it first went into effect when Bush was president. He really opposed it, believing that Americans would be unfairly treated for political reasons. And they actively pursued a policy of hostility towards the court in its international relations, exceeding merely staying out of the statute, instead following the provisions of the American Service Members Protection Act and seeking to guarantee U.S. citizens be immune from the court to thwart other states from acceding to the statute without taking U.S. concerns into account. The U.S. vigorously pressed states to conclude Article 98 agreements, bilateral immunity agreements with the U.S. that would guarantee its citizens immunity from the court's jurisdiction, threatening to cut off aid to states that refused to agree. They tempered their opposition to the ICC in the second term after John Bolton had left the administration. The United States did not oppose using the ICC to prosecute atrocities in Darfur, Sudan, as evidenced in the U.S. abstention of the United Nations Security Council resolution. But they were helpful. As I said, the Obama administration started working with them, and that they decided that the U.S. would end its hostility towards the court. They expressed the U.S. support for the court's investigation into Sudan. They removed the sanctions to the BIA, signaling a positive shift in the U.S. cooperation. They sent a large delegation to the review conference for the Rome Statute in Kampala, Uganda, in May and June of 2010. It seemed like it was a successful assessment to the Rome Statute system. And they even co-sponsored a side event with Norway and the Democratic Republic of the Congo on building the capacity of the DRC's judicial system to address atrocity crimes. The U.S. announced 2 pledges at Kampala and was the only non-state party to make a pledge. The U.S. formally committed to the building of a legal capacity of certain countries to prosecute atrocity crimes themselves and assisting the ICC in its investigation and prosecution of the leaders of the Lord's Resistance Army, a rebel group originating in Uganda led by Joseph Kony. In 2018, Donald Trump took office and had office and criticized the court before the United Nations. In his speech, he condemned globalism and the overreach of international agencies. He drew parallels between the court and the United Nations Human Rights Council. The United States took only the responsible course. We withdrew from the Human Rights Council, and we will not return until reform is enacted. For similar reasons, the United States will provide no support in recognition to the International Criminal Court as far as America is concerned. The ICC has no jurisdiction, no legitimacy, and no authority. The ICC claims near universal jurisdiction over the citizens of every country, violating all principles of justice, fairness, and due process. We will never surrender America's sovereignty to an unelected, unaccountable global bureaucracy. In 2019, the United States revoked the visa of the prosecutor of the International Criminal Court, Fatou Bensouda, in anticipation of later investigation into possible war crimes committed by the U.S. forces during the war in Afghanistan. The investigation was authorized in March of 2020. In June, Donald Trump authorized sanctions against ICC in retaliation for the aforementioned case. His Secretary of State, Mike Pompeo, called it a kangaroo court. When Joe Biden became president, he lifted the Trump-era sanctions against Bensouda and the head of the ICC's jurisdiction, complementarity and cooperation division, Secretary of State Anthony Blinken, issued a statement maintaining the country's longstanding objection to the court's efforts to assert jurisdiction over personnel of non-states parties such as the United States and Israel. However, he added, our concerns about these cases would be better addressed through engagement with all stakeholders in the ICC process later than through the imposition of sanctions. Even though they're not a member, Biden has welcomed the ICC's decision for the arrest warrant of the president of Russia, Vladimir Putin, and the Commissioner for Children's Rights, Maria Lvova-Belova, during the Russian invasion of Ukraine. Later, there were more warrants issued, and in 2024, the House passed a bill to sanction the ICC prosecutor, stating the U.S. would not comply with any ICC arrest warrants. November of that year, the White House said that the United States fundamentally rejects the ICC's decision, adding the ICC does not have jurisdiction. Biden called the arrest warrant for a Netanyahu outrageous, and Senator Lindsey Graham from South Carolina called the ICC a dangerous joke, and for sanctions on the ICC in a bill already proposed. In 2025, the House of Representatives passed the Illegitimate Court Counteraction Act by 243-140 to sanction the ICC in protest of its arrest warrants of Netanyahu and Gallant issued in November 2024. January 20th, after President Trump was inaugurated, he signed further sanctions in a EO, and it further states that the International Criminal Court does not have any support to investigate, arrest, detain, or prosecute a protected person of the United States. The website Human Rights Watch has a list of information about the ICC, and among that is the safeguards at the ICC to prevent politically motivated cases. Numerous safeguards are set out in the Rome Statute to prevent frivolous or politically motivated cases. Unless there is a referral from a state or the UN Security Council, the ICC prosecutor is not able to begin an investigation on her own initiative. It requires an authorization from a pretrial chamber of 3 judges in all investigations. The prosecutor needs to apply to the court's judges for arrest warrants and to confirm charges prior to trial. It's incredibly protected and checked and balanced. It's very interesting.